When clarity matters most, Northgene makes legal DNA testing simple and reliable. Our accredited tests deliver accurate, court-admissible results, helping family lawyers and their clients resolve matters quickly and confidently. Learn more at northgene.co.uk.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Family Lawyer podcast. Today I have Sophie Lougher, Director and Senior Solicitor of Zeus Family Law, alongside Kathryn Fanstone, who's a solicitor at the firm. And the topic of conversation is changing dynamics of co-parenting, particularly pre and post-pandemic. We've just been talking before we started the recording about how the pandemic in particular has impacted co-parenting in the sort of short to medium term after divorce or after separation. Thank you both for joining. Before we start into the meat of the discussion, it's always nice to get a feel for who our guests are. So in the first instance, Sophie, perhaps you could give us a bit of insight into who you are and what you do, please.
So we are a niche family law firm in Cardiff that was set up during the COVID-19 pandemic. I've got a young family myself, and I struggled during COVID because we didn't have any childcare, and I had to hand in my notice where I was, and I had a very big client following, and it just sort of followed naturally, really, that I should set up on my own. So I did that, and we've been growing ever since. We've got a small team, but we are on the rise.
Thanks, Sophie. And Kathryn.
So my name's Kathryn. I'm a junior solicitor at the firm. I qualified in 2024 after completing my training contract at Zeus. I was always really interested in boutique family law practice, just having that additional client care aspect and more client contact. And throughout the training process, I've very much stayed true to that, as it is the firm's sort of ethos. And since then, I've specialised in divorce, finances and children primarily, but I also take on a lot of Trust of Land Act work, dealing with cohabitees and providing guidance where there isn't really any.
Fair to say that very little guidance around cohabitation, isn't it? Not the topic of conversation today.
No.
So, going to talk about co-parenting dynamics and the differences that you've seen as a firm in the attitudes towards parenting, particularly after the pandemic. Give us some context here behind how you viewed co-parenting pre-pandemic, what happened during those COVID years, and what's happening subsequently.
I think pre-pandemic, it was definitely a case of pushing parties towards reaching an agreement that was going to be practical and worked on the ground. Whether or not they chose to have that endorsed in an order or take out contested proceedings to achieve that would depend on a case-to-case basis. But I think a lot of people definitely saw it a lot more black and white previous to COVID, because it would very much be a case of the children are with me this day, and then that would be the status quo with their co-parenting relationships going forward. But certainly during the pandemic, even as a lawyer, there was very, very little guidance in terms of what to advise people and how to go about them actually achieving shared care or other dynamics, especially when there was a difference in opinion around the pandemic between parties. Eventually, the government did come out and provide guidance, and that did help, but there certainly was a short period where nobody was really sure on how people should manage those dynamics, and it was sort of something that developed quite naturally over the course of the pandemic. And it was sort of really learning how to apply the existing principles. We're looking at the best interests of the child to the new normal, and working out how on earth we would help parents to adhere to a court order and to allow the children to have contact with both parties.
And the crux of the issue here is that, of course, during the pandemic, you couldn't move between households. You were stuck in your bubbles, and therefore orders that created the requirement for children to be at one parent or the others really fell a little flat.
There was a lot of uncertainty around the court orders that were in place, and parents didn't know whether they should be upheld or not. And it was difficult as a lawyer to advise them whilst we were waiting for any guidance at all. But we generally did it on a case-by-case basis. And as long as people weren't testing positive, we were very much encouraging them to adhere to the court order. Or if there wasn't a court order in place and there were just informal arrangements, we again encouraged them, just because it's in the children's best interest to see both parents, and we're trying not to have the children affected by the pandemic as a nation. And if they stopped seeing one parent because of it, that would have a really dramatic and detrimental impact on the children themselves. So we tried to avoid that as much as possible. And, you know, there was always the sort of question at the back of our minds whether, if a court order was breached and there wasn't a justifiable reason, would that lead to enforcement proceedings? But generally, we took the view that the courts would give us and the parents a lot of discretion due to the uncertainty for all.
Extenuating circumstances. It's a little glib to say that the pandemic and COVID changed things for everybody, because of course they did. But a little like, and perhaps if you don't mind the comparison, a little like working from home, which has now become much more the norm rather than going to the office. What you've seen in the period since the pandemic then is this rise in a slight change in the way that parents actually behave and act, in that the child remains at home and it's the parents who leave the property and come back so as not to impact the child quite so much.
Yeah, we're finding there's a really huge increase in that, actually. And they're referred to as nesting arrangements. But when parents initially separate, a lot of them, I mean, I've got a few cases where that's actually happening. The parents will actually leave and go and stay elsewhere, whether it be back with their parents in their family home growing up, or in a rental property which the parents share between them, depending on the care arrangements for the children. But just to maintain that stability for the children at that tentative period.
Yeah, it can be a really helpful way for the children to adjust to new arrangements and spending time separately with both parents, because they remain in the property that they've most likely grown up in, and they're very used to remaining in the home. And then the parents coming and going, though it will be different for them, it is helpful for them to adjust. The only thing I would say is that it isn't really a long-term practical solution for a lot of families. The court are quite reluctant to make orders, especially if there's concurrent divorce and finance proceedings going on, because quite often there just simply isn't enough money in the pot to facilitate the purchase of 3 properties, one of which the children remain in. So it can be a really good workable short-term solution, and obviously can continue in the long term if the circumstances allow.
Yeah. One thing I would say, and just to add to that, would be it's proven quite successful from a child's point of view, but not from the parents.
Right.
It actually causes a lot of animosity from the parents as that arrangement continues, just because they're moving back and forth and expecting the other party to actually uphold what they say they will, such as keeping the house as it was, filling up the fridge, just the general day-to-day living. When parties are separating, they're not always the most kind and caring and thoughtful to each other. So actually, what I do find is, although it's workable initially for the children, it actually causes a lot of contention between the parties themselves moving forward.
It's very possible, of course, that one of the reasons why the separation has happened is because of whatever's happened in the home, of course.
Yeah.
But these are sort of temporary circumstances then. Are they informal arrangements? Are you able to formalise them? I mean, you talk about the courts are reluctant to sort of formalise them, but can you formalise them in the short term?
There's nothing stopping you from making a bit more of a formal agreement in writing in respect of that. But in terms of a child arrangements order,
we all know that family law cases can be complicated, which is why you and your client deserve reliable, hassle-free drug and alcohol testing services. From hair testing to abstinence monitoring, we can help. Visit lextox.co.uk for more information.
Well, you wouldn't apply, because if you haven't lived separately for over 6 months, the child arrangements order isn't enforceable. So the question is, does the family home and parents actually leaving that count as parties living separately or not, in terms of a place of residence? So that it kind of opens up another realm of questions there. And the courts are, because now Family Children Act proceedings in the family proceedings court before magistrates and a legal advisor, I find that they very much err on the side of caution. So whereas prior to that, it used to be before a district judge who would be slightly more robust in their decision making. And so if something's not completely clear cut, they'd be a bit reluctant to go there and actually formalise it into an order. And essentially that's what you're asking them to do. Well, the arrangements are up in the air and the parents have got an informal arrangement between themselves to leave the property, say 3 nights a week, and come back. It's clear that that's not going to be workable in the long term, especially if the family home's got to be sold in the divorce. So,
and the court are very much focused when making an order as to whether it will stick. They really are reluctant to see parties back again. So if it was a case that one party wanted to formalise the interim arrangements, then I would be reluctant to advise issuing court proceedings on that basis if it was clear that the arrangements weren't final, because then that just puts the parties through more pain going through the court process again unnecessarily.
Who's advocating for this as a way in which you can kind of co-parent? Is it the parents that are doing it? Are you making that suggestion to them because you're seeing this rise in its popularity?
For me, it's very much from the parents' point of view. A lot of my clients actually come to me and say that that's what they've been doing, but it's not working.
Yeah. I find it almost bizarre, because of course you've got this very traditional, inverted commas, view of people separate, perhaps one party leaves the family home, and then, as you say, children float between them. The fact that the parents are the ones that kind of float between the properties, that almost seems a bit new age.
It really is. It's been a really recent development in terms of actual arrangements, but again, what we do find is that it does have an impact on the parent trying to have a sort of adult life with responsibilities, work often, and have such an unstable set of living arrangements.
It's very time sensitive.
Yeah,
and that's why clients with Children Act proceedings on the imminent really come to us for the advice, because they just say, I've agreed this, I don't, it's just not working, because it's a little bit like you're still in a relationship, really, just working separate shifts or something. Yeah, I mean, it just causes a lot of tension then between the parties, and it's not in every case, but it is just on the increase.
It can certainly work. I think in cases of amicable separations, where the parties have both accepted that the relationship has come to an end and are genuinely focused on the best interest of the children, it is really very much a case of weighing those versus the impact on the parents themselves.
But I wouldn't advise it. That wouldn't be the advice I would give a client. I think at the beginning of divorce proceedings, everyone benefits from actually separating and having that I suppose, time out, I suppose, and actually and the space to actually start decompressing and thinking about what it is you need and want, and how you're going to actually live a new life separately from your spouse. Whereas if you're just going back and forth, and the children, it's very child-led, the nesting arrangements, isn't it? And And I mean, I wouldn't advise it, but it can work.
Yeah.
And it's on the increase, very much so.
Yeah.
I hear the argument about the fact that there's a benefit to the children, but there's a point in time where that benefit becomes outweighed by perhaps the animosity between the parents, or perhaps, and I hesitate to use the word toxic culture, but you could see, and I sense from what you're saying, that actually that benefit will get outweighed. I mean, there's no definitive timescale against that, but presumably you're starting to see that happen as well.
Yeah, I'd always advise clients to very carefully weigh up the benefits and drawbacks of such an arrangement and really consider it in light of their personal circumstances, because no two families are the same, and whether or not they think it's going to work going forward, especially on an interim basis, it is very much a case of weighing up the impacts on you.
Yeah, I think it's a very idealistic way to proceed in terms of separating. I think parents think it'll work and it's for the best, and then in practice the reality kicks in and it's not. Because to give a bit of anecdotal, I've got a client whose former husband took his new partner back to the house and left the washing up for her to do and said there was leftovers in the fridge. Doesn't
it is very much a case of weighing it up at every juncture and having really clear boundaries. And if you're comfortable having clear discussions with your former partner about those boundaries, then that is something I would very much encourage. But if you're not, and you're not perhaps on speaking terms, then it is simply something that's just not going to work, because you're not able to have those ongoing conversations about the benefits and drawbacks of the position.
It's interesting to hear you say that you wouldn't endorse this as a route for parents to go down. And it's got me thinking about some of the challenges that exist for practitioners when it comes to that mediation between parents as well. I mean, for example, have you seen an increase in the number of disputes around, I don't know, I mean, vaccinations was a big topic during COVID, wasn't it? Because of course one parent may have wanted them to have a vaccination, or one parent may not have done. Has that kind of been something that's come out of the pandemic in your experience?
I mean, from my point of view with my clients, there were the discussions at the time, there were the disputes, and both parties have parental responsibility, so it's generally the parent who had the children in their care would end up, their view would prevail, unless one of them really didn't agree and wanted to issue an application to stop them from doing that by way of a prohibited steps order. That's a very extreme measure to take. Since then, I don't feel that there's been anything additional really, other than the normal disputes that parents have as to where the health concerns and where children would go to school, the general parental responsibility arguments. But certainly at the time of the pandemic, whether parents should be vaccinated, because what we did find was that if one parent was vaccinated and the other one wasn't, and someone tested positive, the parents that hadn't been vaccinated had to wait longer then to see the children. But that was a personal decision of theirs to take at that, and they had to then deal with the consequences, I suppose.
I think with any decisions regarding medical care, it is always quite a hot button issue, because the parties, if they are opposed, they tend to be very very opposed to it, and it can be one of those issues that does cause loggerheads, leading to a prohibited steps order being made. But especially in the case of vaccinations, the court are always going to deem receipt of medical treatment in the child's best interests. So though one parent may be opposed, it is a case of reviewing it in all of the circumstances and considering what view the court will take.
Here we have a scenario where perhaps historically one parent takes on the bulk of the responsibility for looking after the child, typically the mother, of course. But in the scenarios that we've been talking about today, where the children remain in the household, that dynamic changes, doesn't it? Suddenly, I guess it depends on who's there more often or whatever that looks like, but there's almost a a joint responsibility rather than one parent having sort of more. You're nodding along. You've certainly seen that dynamic sort of shift then in the course of how this plays out.
Yeah, absolutely. Because both parents have parental responsibility, essentially in law, they have completely equal rights in respect of that child or their children. So if parents are in dispute and just simply cannot agree, the only option is to issue an application to court and have somebody else make that decision on their behalf, which isn't an ideal situation, because any third party, i.e. a magistrate or legal advisor generally, doesn't know the family, doesn't know the children, doesn't know what their morals, and they're relying then on parties to make representations as to their positions and why, and have to make a decision based on that. But yeah, I do find that that's the difficulty. But that's where the court does come in, is when parents just simply cannot agree.
Or when parties aren't able to reach an agreement. But I certainly think an important part of our advice when we're dealing with a parent who has historically been the primary carer is to allow matters to settle, allow the other party to learn to be a parent in their own right, and trust that they will make the correct decisions whilst the child is in their care, because that can also be a really hard adjustment period for a lot of clients. Is if you're used to having that responsibility and bearing that responsibility, it is very much the element of letting go and allowing the other parent to parent in the best way that they see fit, because there are going to be differences. No two parents parent exactly the same, but I do think it's very important for parties to really consider that they need to sort of pick up their share of the responsibilities post separation, and it needs to equal out, and they need to be allowed time to do that.
Yeah, I mean, I find it works both ways. You either have one parent who's been a primary carer who then has to let go and allow the other parent to parent how they will. You find that causes the primary carer to criticise a lot and think that their way is the right way. And depending on who you're acting for, you have to advise that it's not, and that there is no right or wrong way to parent on a day-to-day basis. Obviously, the decisions about children and whether you're keeping them safe, is fundamental. But in terms of how you put them to bed or what you'd feed them and things like that, the primary carer in that instance just has to let go. I've had cases where a lot of the time fathers don't realise how much the right they have from a legal point of view, and that they've allowed children to leave and go and live somewhere else because the mums said that they're going to, and they think that they have to let the children go, and it's just not. And I think that's something that's been another big change, really, is actually learning to co-parent
in an effective
way and put your faith in the other parent, because a lot of the reason relationships break down is because you don't have that faith and trust in a relationship, and then you've got to sort of extend it to the children, and you've just got to let go, and it can be a struggle. But as long as you give them the right advice and don't mislead them, and so even if for example I was representing a mum who'd been a primary carer and was trying to criticise the father at every juncture, you do have to manage that, and
you need to be realistic about what the court will consider. Because there is a risk when you're throwing up a multitude of issues. That the important issues may fall by the wayside, and it's about focusing on what is important and really making sure that I think it also highlights the importance of early intervention and early advice, because if you do seek advice at the earliest possible juncture, then you've got the ability to shape your attitudes and think about how you're going about it, because a lot of people simply don't know, because they never think they're going to be in this position. Obviously, none of us do, but that is our job, is to advise people on how to process and how to approach situations.
But very much with the law in mind. So not just massaging their egos and what they want. It's to actually give them the tools and either pull them back or encourage them that they are actually right and they do have those rights.
I've touched on a genuine kind of lack of understanding that the general population has about the law, not just family law, in previous podcasts, and it's a real soapbox of mine, so I'm not going to get on that one right now. But I do want to ask you about whether the efforts to change the language of family law to this less confrontational style is having an impact on you as practitioners when it comes to how you're dealing with co-parenting and your advice to co-parents. And I mean, again, without being too glib, are we now much better at trying to encourage a bit more kindness between warring couples?
In short, yes. I think it does help guide lawyers into manoeuvring the way that they would advise clients in terms of the language that they use and to focus on, because when I started practicing, it was very much a residence order and contact order, and it's moved very much away from that now, and it has it's assisted me, I suppose, in seeing that parental responsibility is equal, and the law is now recognising that.
I do think it's ties hand in hand really with the rise in the encouragement of alternative dispute resolution as well. We are very much encouraged to keep things as amicable as possible, and that's certainly something we advise our clients at every juncture to consider. I mean, in some cases it's simply not appropriate, but we do ensure that even when we're corresponding with the other side and they have solicitors instructed, that we ensure that the language is very much child focused. If there's an issue, we raise it in a way that's sensible. Obviously, there are times where difficult issues do have to be discussed in correspondence, and that can come off perhaps to a layperson as aggressive, but that's certainly not the approach that we take. It's very much a case of ensuring that things remain as amicable as possible through the circumstances, and that we're encouraging those alternative dispute resolution tools at any point that it's appropriate.
We are fast running out of time for the podcast, and I just finally wanted to thank Sophie and Kathryn for your time in sharing your insight in the discussion. Really interesting to hear about this changing dynamic of parenting, and if we're sat here thinking, well, this happens in major cities or in London or something like that, perhaps somewhere that might be considered to be a bit further ahead than the rest of the populace. You guys live in Cardiff, in a not particularly sort of salubrious and wealthy area, and this is happening where you are. So this is absolutely happening in the regions as much as it is happening in central places.
Most definitely. I think it can be very difficult for especially low-income parents to understand how to approach issues of this nature as well, because there may just simply not be the funding in place to fight a lengthy legal battle in respect of child arrangements, and it is really about ensuring that clients are advised to act in the best possible way in light of their circumstances. And it certainly is, people separate no matter where geographically you're based, so it really is a case of ensuring that your advice is tailored to each individual set of circumstances.
Brilliant. Well, thank you so much to you both for joining the podcast. It's been great to have you on. Thank you, Sophie.
Well, thank you. It's been very insightful, and I'm very grateful for you having us.
Thanks, Kathryn.
Yeah, thank you very much for having us.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on todaysfamilylawyer.co.uk. My thanks to Sophie and Kathryn. Thank you as ever for listening, and we'll see you again soon.
Vacancy Legal Recruitment, a refreshingly unique and personal talent agency developed specifically for legal. Dedicated to the sector and with extensive experience working across legal services and legal technology, we bridge the gap between your requirements and top-tier legal talent. Get in touch today and say hello at vacancy.co.uk.